Lesson: Key clauses to address risk, force majeure, indemnity. Addressing risk in contracts is a critical component of effective risk management and compliance. This lesson focuses on two key clauses that are integral to mitigating risk: force majeure and indemnity. Understanding and drafting these clauses with precision can significantly reduce the exposure to unforeseen liabilities and ensure that contractual relationships are maintained even in adverse circumstances. Force majeure clauses are designed to protect parties from obligations that cannot be fulfilled due to events beyond their control. These events, often termed as acts of God, include natural disasters, war, terrorism, and other extraordinary circumstances. The inclusion of a well-drafted force majeure clause provides a clear framework for what constitutes such events, the obligations of the parties when these events occur, and the processes for notification and resolution. For instance, after Hurricane Katrina, many businesses invoked force majeure clauses to excuse their non-performance due to the disaster. A practical tool for professionals is the force majeure checklist. This checklist ensures that the clause is comprehensive by including clear definitions, specifying notice requirements, outlining the effects on performance obligations, and detailing mitigation responsibilities. Employing a structured checklist aids in drafting clauses that are robust and adaptable to various unforeseen events. On the other hand, indemnity clauses allocate risk by obligating one party to compensate the other for certain losses or damages. These clauses are essential for managing potential liabilities that might arise from the contractual relationship. A well-drafted indemnity clause specifies the scope of indemnity, the types of losses covered, and any limitations on indemnity. For example, in construction contracts, an indemnity clause might protect the contractor from liability for injuries sustained by subcontractors under certain conditions. Professionals can utilize an indemnity clause framework, which includes setting clear indemnification triggers, defining the extent of liabilities covered, and establishing procedures for claims and dispute resolution. This framework ensures that the clause is enforceable and that both parties understand their responsibilities. The application of these clauses in real-world scenarios requires a strategic approach. First, identifying the specific risks associated with the contractual relationship is crucial. This involves conducting a risk assessment to understand the potential impact of various events on the contract's performance. For instance, supply chain disruptions can have significant ramifications, making it essential to include such risks in the force majeure clause. Once the risks are identified, professionals should tailor the clauses to address these specific risks. This customization ensures that the clauses are relevant and effective in mitigating the identified risks. Moreover, it is essential to consider the jurisdictional differences in the interpretation and enforcement of these clauses. Different legal systems may have varying requirements for what constitutes a force majeure event or the enforceability of indemnity clauses. For example, in civil law jurisdictions, the concept of force majeure is often explicitly defined in legislation, whereas in common law jurisdictions, it is largely governed by case law. Understanding these differences is crucial for drafting clauses that are compliant with local laws and customs. Case studies provide valuable insights into the practical application of these clauses. In the case of Transfield Shipping Inc. v. Mercator Shipping Inc., the interpretation of a force majeure clause played a pivotal role in the resolution of the dispute. The court's decision highlighted the importance of precise language in defining force majeure events and the need for clear notice procedures. Similarly, in the case of Wood v. Capita Insurance Services Ltd., the interpretation of an indemnity clause was central to the dispute. The case underscored the necessity of clarity in drafting indemnity provisions to avoid ambiguity and litigation. Statistics further illustrate the significance of these clauses in managing risk. According to a survey by the International Association for Contract and Commercial Management, 73% of organizations have invoked force majeure clauses in response to the COVID-19 pandemic, highlighting their critical role in mitigating the impact of global disruptions. Similarly, The report indicated that 68% of businesses have relied on indemnity clauses to manage liabilities arising from contractual relationships. These figures demonstrate the widespread reliance on these clauses and the necessity for professionals to master their drafting and application. In conclusion, force majeure and indemnity clauses are indispensable tools in the arsenal of contract risk mitigation. By employing practical tools such as checklists and frameworks, professionals can draft clauses that are comprehensive, clear, and enforceable. Conducting thorough risk assessments and considering jurisdictional differences further enhance the effectiveness of these clauses. Real-world examples and case studies provide valuable lessons in the application and interpretation of these clauses, while statistics underscore their critical role in managing contractual risk. Mastery of these clauses not only mitigates risk, but also ensures compliance and fosters resilient contractual relationships.